our thought was, in relation to these online lectures, was to have a 3-part series covering a variety of human rights issues which are relevant to the times we're living now. It's nothing too deep. It's more of a basic insight into the functioning of human rights today, and what we mean by human rights and what the legal framework is. And then tomorrow we'll be looking at misinformation and hate speech online, kind of seeing, you know, how the internet affects our receipt of information and our expression, and some examples of the current misinformation going on with the coronavirus situation. That's the last lecture. And tomorrow we're looking at our right to health, which is a 2nd-generation right that is provided for by international, European, and most domestic law. So a little bit of background. These lectures are going on within the framework of EU POP, which is a Jean Monnet module, EU co-funded project on populism. And what we're looking at is populism and also some different manifestations of populism. And just for those of you who don't know me, I'm Natalie. I'm a lecturer in European Union law and human rights at UCLA Cyprus, and I'm the module lead for the Jean Monnet module on populism. So I'm reckoning that this is going to last for about an hour or so, and then we can have a Q&A at the end and some kind of discussion. So if you have any comments you want to make, if you have any questions, just note them down for the last part. And I assume that you can all see my screen. If not, just let me know. All right. So human rights is quite a fashionable word that we hear at uni, in the media, lots of places. But do we actually know what human rights are? I'm not sure. I'm always really aware of what they are, because for a lot of people, human rights means something very, very different. And we always have to keep these perspectives in mind. However, there are basic characteristics of human rights which have been developed predominantly post-1945. And notwithstanding any kind of interpretation you have of human rights, this is definitely, there are certain characteristics which are definitely of utmost importance in your understanding of human rights. So, human rights are universal. Human rights are interrelated, and human rights are interdependent. So in order for us to subsequently understand the right to health and misinformation and hate speech and free speech and all that, we need to have a basic understanding of what human rights are. So these are 3 key characteristics of human rights. And what do we mean by them? Universal human rights. Every single human has human rights. Doesn't matter where that human is, who that human is, what gender that human has, what political affiliation he or she has, what religion he or she has. Every person has human rights. That doesn't matter where they are located. And this is a very, very basic precept of understanding human rights law. It may seem, you may be wondering why she's spending 2 or 3 or 4 or 5 minutes discussing that we all have human rights. Well, it may seem logical at first, but we really need to embed it in our mind because there's a lot of argumentation in the way human rights are interpreted and applied in certain states, for example, which may not be so human rights friendly, in states which allege to be human rights friendly but may not be so friendly to certain groups. So I can think of some examples such as, I don't know, domestic workers or refugees or asylum seekers who may not be enjoying their human rights as they should be, as both morals and law says that they should be, even in countries which argue that they are, liberal democracies. So we always need to remember that actually, human rights are for everybody. And the other thing that we always have to keep in mind, and you're probably already thinking this, is, okay, well, this is all a nice story and quite romantic and quite sweet, but this is not what's going on. Just look at refugees fleeing from war and trying to get into Europe. Look at their situation. Look at what's going on in I don't know, Evros in Greece. The domestic workers, I'll give you the example of Cyprus, who are living in the homes of their employers and working many hours a day in a lot of situations. Look at, a variety of such themes, reflecting the fact that actually, although human rights and the different laws that we're going to look at today say that, we all have human rights, the reality is very, very different. And that reality worsens when the political situation in a country worsens. So if we look at, for example, the classical European examples of Hungary and Poland, whereby their governments are becoming increasingly leaning to more totalitarian regimes, whereby the rights of minorities are deteriorating. We saw what the Prime Minister of Hungary did now with the coronavirus crisis and the different emergency situations he announced so that he could gain more power. I mean, there are situations even in regions and areas which are considered to be developed, whatever that may be, whereby the situation of human rights is tricky. So we must always go back to the basics. And even if you're thinking, okay, this is a very romantic image of what the world should be, well, I can tell you something. If we didn't have human rights law and we didn't have those benchmarks set by institutions such as the United Nations and the Council of Europe, the two major institutions in human rights protection, which we're going to look at for all three lectures, then what would we have to work towards? We'd have nothing. We'd have nothing, and no government, regime, or state would have any kind of framework to answer back to. So it doesn't matter if you're thinking that this is sounding just a little bit too romantic. The fact remains that we need that very, very basic benchmark of human rights, universal human rights. When we, hang on, sorry, someone's trying to join. Hang on, sorry about this. Someone is trying to join. Hang on, and I have added her now. Okay, great. Right, human rights are also interrelated and interdependent. What does that mean? It's not sufficient for us to just be enjoying some of our rights. In order for us to live in a culture of human rights, it's as simple as that. We need to be enjoying all our rights. And again, this sounds very, very basic and very, very reasonable and logical. But at the end of the day, we need to have this kind of link between the different human rights. And I'll give you an example. We see in a lot of textbooks a young girl going to school with an empty stomach. Is that a situation of justice? Is that a situation of human rights? Is the fact that that young girl is receiving education sufficient? Not really. So we need to ensure that we are enjoying everything. And again, this is hard work, even in liberal democracies, predominantly with second generation rights, such as the right to health that we're looking at tomorrow, because that right requires money. Now, I'm very sorry, but I think someone's trying to join and they can't. So let me just add IT. I've just added IT so that that person can join. Okay. Okay. Okay, I think we're sorted. All right. Now, so those are the very, very basic characteristics of human rights: universal, interrelated, interdependent. Now, let me tell you something else very, very important. In order for us to understand human rights and contextualize in our times today, and be able to use a kind of human rights framework, because human rights are firstly important for every single one of us, because every single one of us here today is a human, but also because of the kind of work we do, whether we are academics, whether we are researchers, whether we are educators, whether we're students training to be lawyers or any other profession. A human rights approach in our work is of fundamental importance to the protection and promotion of human rights. And I'll explain why. It's not just it is predominantly the responsibility of states to protect and promote human rights. But my position is definitely that each and every one of us has to contribute to this kind of creation of a human rights culture. And one of the ways that we can do that is by incorporating and adopting a human rights approach in anything we do, whether that's work, whether that's our, I don't know, extracurricular activities or anything else. So it's important for us to be able to do that, firstly, to understand where human rights came from, and where can we find human rights. So if you finish this lecture and you want to go and look up human rights and see what they are, how would you do that? Now, human rights today are protected by international law and by national law. And I have a link there which you can watch in your own time. I will share the slides with you at the end of the lecture, and you can watch a very short video on what I've just said. But I don't want to spend time on doing that now, because you can do that on your own. So why are human rights important? According to the United Nations, human rights ensure that a human being will be able to fully develop and use human qualities such as intelligence, talent, and conscience, and satisfy his or her spiritual and other belief. Now, the United Nations, as I said, is a major framework for the protection of human rights, because the way we understand and enforce human rights today are very, very much based on the post-1945 international developments in relation to human rights, which we will be looking at. Human rights and human rights laws reflect the minimum standards necessary for people to live with dignity. Now, dignity is a very, very important word. An important concept and an important objective when it comes to human rights law. The whole point of having human rights, the whole point of enjoying human rights, the whole point of having all these laws and documents and deliberations and consultations and everything else is so that we can live in dignity. And this is a very central precept of human rights. Human rights are also important because they give people the freedom to choose how they live, how to express themselves, with whom to associate, what kind of beliefs they want to adopt. So freedom is another very, very important word when it comes to human rights protection. Human rights law guarantees that people have the basic means to satisfy the basic needs of life. Theoretically, what we will see when it comes to second generation rights, so economic and social rights such as the right to health, the right to work, the right to an adequate standard of living, all these different rights have a financial requirement. And because there is a financial requirement, their implementation becomes a little bit trickier. This is not to mean that other rights, civil and political rights, such as the freedom of expression or the right to a fair trial, don't have a cost. If I have the right to a fair trial, which I do have, the state has to, for example, provide me with a lawyer if I can't afford one, and that costs money. So we mustn't, it's not, one or the other, but second generation rights, and I'll get into the generations in a bit, do require the economic input of the state, and this can be tricky at times. Human rights law also protects people against abuse by those who are more powerful. Okay, so it's that kind of mediator between for the relationship between individuals and the government. So we have this vertical relationship of the powerful government and the individual, and human rights law is there to kind of steady any potential abuse, but at the same time impose obligations on the state to ensure that my human rights are both protected and promoted. Rights. So let's look a little bit at the history. That person managed to enter now. Okay. Great. So human rights, as I said before, human rights law as we know it today is very, very much a post-1945 framework. But that doesn't mean that human rights didn't exist before 1945. So I think just out of interest, it's interesting to look at older human rights documents, which I'm sure you know at least most of them. So the Magna Carta, 1215, is a major document in relation to human rights in history. The United States Declaration of Independence of 1776, the subsequent Bill of Rights of 1791, all these national documents provided some form of rights or freedoms for persons. What we didn't have, and this is very important, is an international setting. And this came after the war. And the international setting for the protection of human rights is very important. And when I say the war, I mean the Second World War. So human rights today are deeply, deeply impacted by World War II. With the establishment of the United Nations and the replacement of what was previously known as the League of Nations. There was this never again objective that was deeply endorsed by the UN. And this is very, very reflected in the Universal Declaration of Human Rights, which is a non-binding instrument developed post-World War II in order to set out certain human rights. It was a symbolic movement of the international community to essentially come and say, you know what, we are now together, we are now functioning as an international entity, and we are going to work towards ensuring the proper protection of human rights. And the Council of Europe, again, born out of the ashes of World War II, whereby we have the establishment of the Council of Europe, which works towards the protection and promotion of human rights. We have the European Convention on Human Rights. We have the European Court of Human Rights, which I'm sure we all know, based in Strasbourg, which is there to monitor the proper implementation of the European Convention on Human Rights. Now, a few pieces of information, but also some of my own ideas. The impact of World War II, of the devastating effects of World War II, are great when it comes to human rights law, because we, as an international community, started developing this idea of an international community there to protect and promote human rights. We had the symbolic movement of the Universal Declaration of Human Rights, followed by other more binding documents. But we also have some trouble, or some, let's not say trouble, limitations. and I'll give you an example. The freedom of expression is a fundamental freedom. We all need to be free to express ourselves. Now, post-World War II, however, the way freedom of expression was incorporated in the major international documents, but also in the European Convention on Human Rights, was with quite a bit of limitations. So, for example, Article 10 of the European Convention on Human Rights provides for freedom of expression and also reminds people that this freedom comes with duties and responsibilities. This is a qualification that is not made when it comes to other rights. This is because at the time of drafting, the drafters of the ECHR realized that, or believed, that with expression can come a lot of bad things, because if I express myself and I'm promoting something which is against the basic precepts of democracy, I can convince others to believe that too and come along with me. This is in a very, very basic nutshell. This is what we call in legal theory the doctrine of militant democracy. The fact that certain human rights should be restricted in the event that there is a potential for them to be abused and subsequently destroy democracy, right? So this is the doctrine of militant democracy. And that doctrine of militant democracy has infiltrated in a variety of UN documents. So, for example, Article 19 of the International Covenant on Civil and Political Rights, which we'll look at in a bit, provides for free speech, but essentially limits it if that speech is, for example, to harm somebody else or to harm public order or public health or public morals or the reputation of others or anything else. And the same kind of template is adopted in the European Convention on Human Rights. So as a first thought, you may say, yeah, that's logical. I can express myself as long as my expression isn't going to harm anyone else. But is it really a very clever idea to do that, or a very good idea, or a very effective idea? Firstly, who determines harm? As we will see in our last lecture, we've got a series of countries around the world passing different anti-fake news legislation. We have the example in different countries in Eastern Europe, for example, whereby different conceptualizations of harm are essentially abused by the states in order to silence people and censor potentially anti-government speech, which is actually necessary in the functioning of a democratic society. So we have to be very, very careful when it comes to restricting human rights. And unfortunately, what we do see on an international level, both within the United Nations and the Council of Europe, we do have many, many restrictions of human rights. We only have some human rights which are absolute, which should, in theory, never, ever be limited by the state. So an example is the freedom from torture, inhuman and degrading treatment. That is an absolute right. That means that the state can never come and take that away from you. Whereas the freedom of expression, if the state believes that your expression is harming somebody else or someone's reputation, they can come and legitimately restrict it. So it does get quite tricky. And we'll see that again in the last lecture with hate speech and misinformation in Europe, but also in a UN framework. We're very, very keen on this idea of saying, yep, free speech as long as that speech is okay. But we don't really think about it well. A, who's to determine whether it's okay or not? Who's to determine the harm a particular speech entails? And who has considered what the effect could be on haters if you silence them? There's a plethora of empirical work demonstrating that when you actually silence somebody who's frustrated, they can turn to violence more easily. So we really need to start reimagining what I'm trying to say, but I'm turning, I'm going through a maze, is what I'm trying to say is that World War II was, however possible, such a tragic event, but it was positively mobilized by the international community to give birth to this idea of an international cooperation for the protection and promotion of human rights. But at the end of the day, this was 1945. The concerns were that fascism would never rise again. The worry was for example, rights such as free speech or freedom of association or freedom of assembly never to be exploited by totalitarian powers again. So this is just one example. We need to start reimagining things, though, on a more general level, if we are to keep up with the pace of things. Of course, this is not set in stone. I didn't want this just to be a brief overview of what human rights are. I also wanted to give you some of my own positions, born from my research. And this is something that we definitely have to look at. On the one hand, the UN and this whole international community, a huge leap in terms of human rights protection. At the same time, however, we need to be wary of what limitations could mean, what harm could limitations bring, but also what changes need to be made to keep up with society today. And this also stands from the Council of Europe. So, Eleanor Roosevelt's major role for the Universal Declaration of Human Rights and this general idea of an international community for the protection and promotion of human rights, and her very, very famous quotes, where, after all, do universal human rights begin? In small places close to home, so close and so small that they cannot be seen on any maps of the world. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world. So this is a very famous quote of Eleanor Roosevelt. This reflects the importance of microactions and citizen contribution to human rights. And it also reflects the fact that human rights are not just this big idea on an international scale. Human rights have to be enjoyed in every home, in every park, in every school, in every country, as simple as that. The task of making this happen, and if you consider things like economic models, the functioning of finances, etc., this does become quite tricky. But as I said, the benchmark needs to be there. So let's look a little bit at the law, and this will help us with our other lectures as well. The Universal Declaration of Human Rights, as I said, a symbolic document, non-binding. It was the first movement of the international community to come and say, here are the human rights that we are recognizing, and we as an international community are going to contribute to their protection. This was adopted in 1948 by the 56 at the time members of the United Nations. And this reflected the idea that the treatment of people by their states is no longer just a matter of national law. There is someone or something else there to monitor and protect and contribute to the protection of people's human rights. It's not legally binding, as I said, but it was a very, very important movement. And we do have the International Bill of Rights, which exists at a UN level. So, for example, we have the Universal Declaration of Human Rights, which is part of that bill. We have the ICCPR, which is the International Covenant on Civil and Political Rights, and the ICSCR, the International Covenant on Economic, Social, and Cultural Rights. The ICCPR protects civil and political rights. These are what we know as first-generation rights. These are the rights which have been developed to limit the absolute power of the state on us. So such as the right to life, the freedom of speech, the right to vote. Through these rights, through these freedoms, we as people manage to limit that absolute power of the state. So I have the right to vote who will govern me. That person doesn't just appoint himself or herself. Yeah. So that's that basic idea of limiting the absolute power of the state. However, although we call them human rights, I can give you an example: the right to vote. Domestic workers can't vote in Cyprus. Refugees can't vote in Cyprus or other countries. Who votes? The people with citizenship, for example. Even if the other people with no citizenship live for 10 or 20 or 30 years in that particular country, but for one reason or the other, for example, stringent nationality laws, can't get citizenship. So we always have to keep the perspective of the fact that some people are just more equal than others. That goes against the very nature of human rights. But unfortunately, this is the reality. And I see this a lot with refugees. Refugees in this country who have been recognized as refugees or have been granted subsidiary protection and have been living here for years and years and years on end and have applied for citizenship but are not getting it or have been rejected it or anything else, essentially are living in a country where they cannot contribute to who will be making decisions for them. So again, we need to start reimagining things within the current framework. Not everyone living in the country necessarily has that citizenship because the procedures and the processes can get complicated, for example. So is that really fair? I mean, I think that's one of the examples that really stands out for me is the examples of refugees living years and years on end and not gaining citizenship and subsequently not being able to contribute to the functioning of democracy through voting. The ICSCR, this is a document which focuses on what we call second generation rights, such as the right to food, the right to education, the right to health, the right to shelter, the right to an adequate standard of living. And there's this whole argument of, how do we ensure this? How can we force a country to provide this when the provision of these rights are so deeply correlated with finances? And I remember during the austerity measures adopted by the European Union, when the Eurozone had several defaulting countries and we had the crisis, the financial and economic crisis, a lot of these committees and these institutions on an international level, which are there to protect second generation rights, social and economic rights, were basically very, very concerned that these austerity measures would deeply hamper the enjoyment of these rights. And I'll give you an example, and more particularly that they would deeply affect the more vulnerable of all of us. And I'll give you an example. Austerity measures could result in, for example, cutting spending on health, right? Which are, however, the groups who are most reliant on the public health system. Or, for example, austerity measures may result in, I'm giving examples from the European crisis, in cuts on welfare benefits. Well, who are those who are reliant on welfare benefits? These are the more vulnerable groups amongst us. These are the single-parent families. These are the asylum seekers, or these are the persons with disabilities whose life may rely on such. Not always, of course, but may rely on such public spending. So we need to be very, very careful when we are within a financial crisis in order not to disregard second generation rights. This is of utmost importance. And one of my arguments in terms of the European financial crisis is that there was an absolute disregard for second generation rights in the activities of the lending institutions. So the International Monetary Fund, the European Commission, and the European Central Bank. There was a very financial and economic restructuring approach, but there was never really much of that social element of, what is the social impact of these measures? And I think we learned a lot during that crisis. And I hope there's no other crisis, but in the event that there is, especially with the situation at the moment, that we consider the social impact on second generation rights of things like austerity measures, and to never forget that those who rely on public spending a lot, those who can't do without, are the most vulnerable of all of us. And if this is something that interests you, you can let me know and I can send you some work on this. And that's why it's so important to remember the basics, that human rights are universal, human rights are interrelated, human rights are interdependent. They're not just there whenever they're, what's the word I'm looking for, convenient. They have to be there always. Crisis, no crisis. Whether that's a financial crisis, whether that's a public health crisis, as we're having now, I'm quite concerned on the impact of the lockdown on a variety of groups, but also on a variety of groups if a recession will come after this. This is not to say that a lockdown mustn't happen. Of course, I'm not a health specialist, but what I'm saying is that in any measures, and this is what we mean by a human rights approach, in any measures which are subsequently going to be taken, for example, to restructure any economy, we have to keep human rights in mind. And this is what we mean by keeping a human rights approach and human rights mainstreaming. Okay? It's very awkward not being able to see you and knowing if you're bored or not, but I hope you're not bored and you're following me. Okay. All right, so I've put in a few different, someone's written to me, let's see. No, you're not bored, not bored. Great, thank you. Okay, so I've put you a few of the basic documents of the International Bill of Rights, certain documents, certain rights and freedoms which are incorporated therein. You can have a read of a few. Hang on, is someone trying to connect? Okay, okay, so you can read here. Sorry, just to see, someone trying to connect? No, fine. The International Bill of Rights, and as I remind you, it's the Universal Declaration of Human Rights, the ICCPR, the ICSCR. Those are the three major documents on a UN level for the protection of human rights. So let's look at a few of them. The right to equality and freedom from discrimination, the right to liberty, life and personal security, freedom from torture. This is an absolute right. It can never, ever be taken away from you legitimately. It doesn't matter who you are, what you've done, what you know. No state is allowed to touch you. or mentally or psychologically abuse you or torture you, or put you in situations of inhuman or degrading treatments. And this is an absolute right. We do know, however, that this has been illegally restricted by a lot of states. I think this right is one of the most deeply impacted rights post 9/11. So one of the things I tell my students is that there are two important dates when it comes to international human rights law. 1945, because with 1945, as I told you before, we had the birth of, the UN, the different documents of the UN, the Council of Europe, the European Convention on Human Rights. A lot of things happened on an international level. So 1945 and 9/11. Why? Because post 9/11 until today, we've had a major reconceptualization of human rights, a deep embracement of or endorsement, I would say, by several states which purport to be liberal democracies of phenomena such as racial profiling. And we've had the degradation of very fundamental rights, which are also absolute rights, such as the freedom from torture. Suspected terrorists being tortured, for example, in different institutions developed by states. So this is one of the deeply impacted by 9/11. The equality before the law, right to a fair trial, right to privacy. Right to privacy is an interesting one when it comes to developments, technological developments, social networks, these different Alexa and different other apps and artificial intelligence and everything else. The freedom of belief and religion, that's something that I'm going to get back to in a minute. So you can see different ones here: right to health, right to housing, right to education, right of peaceful assembly. Okay, all these, apart from the freedom from torture, are qualified rights, which means that a state may, if it deems fit, and if there's a law that allows the state to limit these rights. So, for example, as I told you, freedom of expression can be limited if, for example, my expression is going to harm the rights and reputations of others. Now, freedom of belief and religion. This is a very interesting one when it comes to the European Convention on Human Rights. And I'm going to note this down so I can remember to tell you when we're back. So what I want you to keep from this chart is that there are two types of rights, or two generations when it comes to the International Bill of Rights, which are first generation rights such as civil and political rights, the rights which are there to limit the absolute power of the state on our life and our existence. So through, for example, the right to vote, and second generation rights, which are rights which we have pursued for purposes of contributing to heightening our standard of living, right? And we do have third generation rights, which have not been yet legally codified. These are what we know as collective rights, group rights, the rights that we are entitled to as groups. And as people as a whole. So, for example, the right to peace, the right to sustainable development, right to a healthy environment, things like that. But they're still under discussion, under consultation. I have nothing to show you in terms of an equivalent of the ICCPR, for example. So that's what I wanted to tell you from there. And another very important thing when it comes to United Nations is, so we have three essential stages. We have the Universal Declaration of Human Rights. Then we have the ICCPR and the ICSCR, so the first generation rights, second generation rights, passed in 1966, came into force in 1976, and all those three together making up the International Bill of Rights. Now, at the same time, and also sometime before that and after that, the UN also considered very well that, okay, there are certain themes and there are certain people who, because of their particular situation or characteristics, need a variation in protection. So this is what we mean by the thematic development of human rights protection. So, for example, in 1965, the UN passed the International Convention on the Elimination of All Forms of Racial Discrimination. This prohibits, for example, in Article 4, racist expression, racist parties, things like that. Again, I'm quite critical of limiting people and groups because of the effect of limiting those groups, but also the danger in having the abuse of this limitation by certain states. But okay, we need to look at it chronologically. The fact that in 1965 there was that continuation of endorsing, the limitation of certain rights. We have the Convention on the Elimination of All Forms of Discrimination against Women. So the UN recognized that women have other needs that need to be protected for in a convention, that their human rights would not be adequately served if women had to rely solely on the two major ICCPR and ICSCR. Now, this convention is very interesting because, as it's one of the first articles, says that states have to contribute to fighting stereotypes. And this was a major, stereotypes against women, this was a major leap in international human rights law and a major leap made by the United Nations. And I'll tell you why. Because stereotypes are deeply harmful for the enjoyment of human rights. And in this framework, when it came to women, the UN recognized that. Okay, so we also have the Convention Against Torture because of the very dire and severe nature of torture and the particularities that need to be included in fighting torture. We have a convention just dealing with that. We have the Convention on the Rights of the Child. This is the most widely ratified convention in the world. And just as with women, the UN realized that, and the international community, that children need certain rights that cannot be provided for in general documents. And one of the very basic tenets of the Convention on the Rights of the Child is the doctrine of the best interest of the child. And this has trickled its way through, infiltrated into international law, in Cyprus at least, and on a theoretical level at least, quite well, this best interest of the child, which basically means that any decision made by any authority, body, institution, government, anything else has to take into account the best interest of the child as a starting point. So, for example, if there's a divorce and there's a custody battle, the court is not going to look at the rights of the mother or the rights of the father to access their children, but rather the best interest of that child. Who should that child be with in order for that child to enjoy or to have his or her best interest protected? And we have the Convention on the Rights with Disabilities. These are just examples, by the way. We have lots more. We have one for migrants and their families. We have a refugee convention. We have several. I just pointed a few out just so you could have a look, both at the kind of groups who are protected and at the kind of themes. Convention on the Rights of Persons with Disabilities, again, very, very important. Now, every single UN convention has a committee. So, for example, the ICCPR, the International Covenant on Civil and Political Rights, has the Human Rights Committee, which is there to monitor the implementation of the ICCPR by states parties, but also to receive individual complaints. Okay, so these are avenues that often we don't know about. It's not just the courts that we can go to. There are institutions on an international level within the framework of the UN who can look at human rights violations, even individual human rights violations. So every one of these conventions have certain committees, and those committees will issue reports on the implementation of the conventions by states parties, but they will also receive and make decisions on individual complaints. The thing is that the individual complaints are non-binding documents, and even if the UN does report on a country, for example, for the Convention on the Elimination of All Forms of Discrimination Against Women, every few years the UN will make a report on the country after receiving a report by the country. They will subsequently make another report to give them advice, tell them how they're doing, what they're doing right, what they're doing wrong. At the end of the day, the state doesn't really have to do much legally when it comes to the report. And that's because the nature of the UN is not the same as the nature of the European Union. The UN is an intergovernmental institution. What does that mean? When I joined the United Nations as a member state, as a state party, I am not giving up my national sovereignty in order to be, or part of my national sovereignty in order to belong to the UN. Whereas when I join the European Union, I do give up part of my national sovereignty when it comes to the areas of competence of the European Union. So anything that the European Union can legislate on, so its area of competences, I give up my national sovereignty. I follow what the EU says. Whereas for the UN, I don't do that. And there's a very, very, very logical explanation why. Think of the UN, over 190 countries with very different political backgrounds, religious and cultural backgrounds, social backgrounds, financial variations. Having a really pressing international body forcing countries ranging from Sweden to Saudi Arabia to France to Russia to follow something as a must, or else there's a penalty, for example, that could dishearten and make people not want to go along with things. So what the UN has done, and I think it's the only model that's really realistic, is have this intergovernmental institution set up whereby there is a discussion, there is reporting, there are deliberations on individual complaints, there are decisions made on those complaints, but there is also more of a diplomatic cooperation between the UN committees, so let's say the Human Rights Committee, and the defaulting, let's say, country. So this is the thematic development of the UN. I'm going to close the chapter of the UN now, and I'm going to look at the Council of Europe. Sorry, let me just have some water. So again, the Council of Europe is an institution born from the ashes of World War II. Don't confuse the Council of Europe and the European Union. They are two separate institutions. I am going to talk a little bit about the European Union in a while, because we don't really have it in our mind as a human rights institution, rightly. However, the protection of human rights within the European Union framework post-2009 has grown dramatically. And we'll look at that later. So for now, the Council of Europe, its institutions are based in Strasbourg. The European Convention on Human Rights, it's an international treaty to protect human rights and fundamental freedoms in Europe. It was drafted by the Council of Europe. The countries which are members of the Council of Europe are the countries of the EU plus more. So countries such as Russia, Armenia. So imagine the broad geographical scope of Europe, and most of those countries are in the Council of Europe. And I'm sure you all have heard of the European Court of Human Rights, and that is the court which monitors the European Convention on Human Rights. So I'm going to give you two examples, and just to show you very briefly, just to show you how the court works. So we have the case of Ranstev versus Cyprus and Russia. Ranstev was the father of Oksana Ransteva. She was a young girl who had come to Cyprus several years ago now, and she had been essentially exploited and abused. She had been brought into the country through what we used to call this pink visa scheme that existed between Cyprus and several countries such as Russia, which facilitated the bringing of women as dancers, in inverted commas, to the island, and those women were subsequently exploited sexually. So Oksana Ransteva had arrived in Cyprus and had been exploited, and she had managed. She was in a what we call cabarets in Limassol, so in my city, and she had managed to escape her abusers. To cut a long story short, she had then been seen by some people who told the owner of that cabaret that she had been seen, and he went and he found her, and he took her to the police station, and he said, I want her to be sent back, I want her to be deported, because he wanted to bring somebody else. It was evident for him that he wasn't going to manage with his horrific mandate, and he wanted to bring somebody else to replace Oksana Ransteva. So he went to the police station and said, deport her. And the police told her, well, bring her back in the morning when the officer in charge is here. To cut a long story short, he took her back to an apartment, and she was found the next day dead on the pavement under the apartment. And there was not much investigation here. We assumed that she killed herself. We didn't really investigate. We didn't do much. And her father sued Cyprus and Russia at the European Court of Human Rights. Let me remind you that in order to reach the European Court of Human Rights, you need to exhaust all the relevant national measures and courts that exist, okay? So he went to the European Court of Human Rights and he said, because of this pink visa scheme and because of different other things, which I'll explain, Cyprus and Russia, I'm moving against them for a violation of Article 2, the right to life, and Article 4, the freedom from slavery, which is also an absolute right, like the freedom from torture. And he won. I won't get, it's a very, very technical decision, but essentially the court said, yeah, this pink visa scheme was wrong. It facilitated the trafficking of women. This was a landmark case when it came to slavery and trafficking. They also agreed that Cyprus essentially did not conduct any proper investigation into the death of his daughter. which violated the procedural aspect of the right to life. So this is something very important, and this comes back to the concept of dignity we spoke about at the beginning. Violating the right to life doesn't just amount from the state directly killing you. So I don't know, a soldier indiscriminately shooting at you and you dying. It also emanates from other things. For example, the state has to take all the necessary measures to protect your life. And at the same time, the state, if you do die, has to investigate your death properly. If it doesn't, it violates the procedural aspect. It's what we call it in the technical term. Doesn't matter for our online lectures this week. It does violate the right to life, because in order for us to live in dignity, when we do die, suspicious deaths, the state has to properly investigate it. So this was the case of Ranstev versus Cyprus and Russia. It was a big case at the European Court of Human Rights. It was a big case when it came to trafficking. It was a major turning point for Cyprus when it came to the exploitation of foreign women and the pink visa scheme. And we also have the case of Modinos versus Cyprus. This was another very, very important case for LGBT rights in Cyprus. Alekos Modinos, he is an LGBT activist, and he had taken Cyprus to the European Court of Human Rights because at the time there was a law which criminalized homosexual intercourse. And he essentially said that the very existence alone of this law violated his Article 8, which is his right to private and family life. And he won. And that was a major turning point again for us in Cyprus when it came to the slow, very, very slow and ongoing recognition of LGBT rights. So I just wanted to give you those two cases as just so you can get your mind across, around how the court functions. Let me remind you that you can only take a country to the European Court of Human Rights, and that country has to be a state party of the Council of Europe. You can't take another person to the Court of Human Rights. It doesn't mean that your damage may have amounted from an individual. So Ransteva had been abused by an individual, even though the police had also ignored her that night and didn't really protect her, or didn't protect her at all. It doesn't mean that it's the state coming and directly violating your right for you to get to this court. It means that something has happened to you here, whether that has been by a private party or by the state, but you consider that the state did not protect you or did not give you justice. So, for example, we have several cases against Turkey when it comes to domestic violence. So, and particularly women of Kurdish origin who had been ignored by the police and beaten by their husbands and subsequently killed by their husbands. We have a couple of cases like that, whereby their families then went to the court and said, you know what, okay, it's the husband that killed her, but she went to the police station and the police just ignored her. And if she didn't find any justice by the courts in her country, which in the Turkish cases, the women's families didn't, they can subsequently, and they did subsequently go to the ECHR. But you can only actually take a country to the ECHR. I'll give you another example. We have several cases against Bulgaria, Croatia, the Czech Republic, which include the lack of investigation of racist motives. So people who had been attacked and in some cases even killed, either by state representatives, whether that's police or soldiers, or by private individuals, people who were of Roma origin. So Roma persons who had been racially, they had they had suffered physical attacks and even suffered death, and there was a racial motive that was not considered by the police, that was also taken to the ECHR against all those countries and considered. And the European Court of Human Rights says that, you know what, when you are investigating abuse or death, the racist motive has to be looked into. Otherwise, the investigation is not done properly. So anyone interested on that, you can look at cases such as Nachova versus Bulgaria. So that was a major landmark in this. Yeah, so I hope that makes it a little bit clearer. Sorry, one moment. I know we have several colleagues from the UK, probably in your media, not probably, I mean, I'm sure, and I've seen it, a lot of the ECHR cases which are covered, especially by tabloid, are like the non-deportation of terrorists or suspected terrorists. There's a lot of cases against the UK going beyond that. So, for example, we have a lot of cases between Irish citizens or even the country, Ireland, against the UK regarding treatment of suspected IRA members of the Irish Republican Army, and cases when concerning Article 3, freedom from torture, but also Article 2, the right to life. Very, very interesting case law on the two very, very important rights of life and torture have been heard at the ECHR against the UK, and as I said, involving the IRA. Something also, just to open a bracket, the right to life is not an absolute right. It's not like the freedom from torture that can never ever be taken away from you. In antithesis, the right to life is a qualified right. That means that a country can restrict the right to life in certain situations, such as if, for example, the state is going to defend someone else by killing you. Let's say you're going to attack someone and there's a police officer there and he shoots you. That can be a legitimate restriction of the right to life insofar as the violence used is reasonable. And we're not going to get into the tests of that. I just wanted to give you an example of how the right to life can be restricted, because often people automatically assume that it's an absolute right. Anything else I want to tell you about the ECHR? I mean, the ECHR has absolutely fantastic cases, very, very interesting cases. Let me give you another one, just as one of the interesting ones. There is an article in the European Convention on Human Rights, Article 17. This is a strange article in the way that it does not provide a human right. It's the non-abuse clause, which basically says that if you are trying to use any of the human rights provided for in the convention in order to abuse the rights of others, then you're not allowed, to enjoy any of those rights if your rights are going to abuse someone else's rights. And I'll give you the example of Mr. Norwood. It's a case against the UK. Mr. Norwood was at the time a member of the British National Party, which was, I don't know, it was much more powerful than what it is now. Not powerful, but larger. He was a member of the British National Party many years ago, and he was running for some kind of local elections or something like that. And he made a very big banner of the Twin Towers in flames, and the crescents, the half crescents in a cross. And then it said at the bottom, "Islam out of Britain, protect the British people." So he made this banner and hang it on his window. So if you would walk down the street outside his flat, you would see this banner or whatever you want to call it. So the police prosecuted him, and he went to all the courts in the UK and lost, and then he went to the European Court of Human Rights. And he said to the European Court of Human Rights, he said, I was exercising my right to freedom of expression. And the European Court of Human Rights said, oh my goodness, no. What you have done is so bad that we're not even going to conduct any legal analysis of your freedom of expression under Article 10. But we're just going to throw out your case because you have tried to abuse the freedom of expression in order to impact someone else's rights. So that was an interesting case of Norwood versus the UK. We're going to look at, these hate speech cases on Friday. They are, apart from Norwood and some other cases involving the denial of the Holocaust, usually what happens at the European Court of Human Rights is an assessment of Article 10 and then a conclusion that free speech does not extend to what the court perceives to be hate speech. So those are a few of the cases. I hope that's helped make you understand how the court functions. Now, let me tell you a little bit about the European Union. The European Union has three major phases in its history, and it's very important to recognize the three major phases if you are going to understand the positioning of human rights within the Union. And it's very important to understand the positioning of human rights in the Union because the areas of competences of the European Union are growing, which means that there's more and more legislation on a variety of more and more themes emanating from the European Union. Therefore, human rights, are very, very important. Since this institution is growing. So how did the European Union start? It started as the European Coal and Steel Community by the founding countries, whereby essentially it was an agreement on coal and steel. Coal and steel, of course, being important for the functioning of an economy, but also they were the raw material used to make weapons, guns, tanks, anything else. So the countries made an agreement to work together and trade on these raw materials. And this initial agreement on coal and steel slowly grew into the European Economic Community, this whole idea of a single market, of the free movements, etc. And that grew into, by 1993 and the Treaty of Maastricht, into the European Union, which is what we know today. It's not just an economic entity. It's an entity of an institution of values, an institution of common missions, an institution of people, institution of countries. It's something very, very different than what it started off to be. And the European Union, a big, most important date was 2009. The passing of the Treaty of Lisbon, which brought a lot of constitutional changes to the functioning of the Union, which we won't go into today or during our lectures, did do something very important for human rights. It made the Charter of Fundamental Rights of the European Union, which is the human rights document of the European Union, which came about in the year 2000, it gave it the status of primary law. So the highest legal status that a European document can have, the human rights document of the Union since 2009 has it. Okay. And this charter contains rights and freedoms under 6 titles: dignity, freedoms, equality, solidarity, citizens' rights, and justice. However, it only applies to certain situations. So, for example, it applies to the European institutions, and it also applies to member states only when they are enforcing EU law. So if a member state is doing something that goes beyond the competence of the European Union and EU law, then the Charter is not applicable. And this was a problem for a lot of the cases brought before the Court of Justice of the European Union, which is the highest court of in the EU. And this was a problem with all the cases nearly which were brought because of the austerity measures. So different claimants said to the Court of Justice, yeah, but these austerity measures are, for example, violating some of my rights in the Charter. But unfortunately, the Charter was not found to be relevant to the austerity measures for a variety of reasons. And I'll give you one of the reasons. Because the three institutions that were lending the money, so the European Commission and the European Central Bank and the International Monetary Fund, they were acting as a trio. None of the three institutions could make a decision on their own. And because one of the institutions was not a European institution, so the IMF, it wasn't a European Union decision. So the European Commission, for example, could not be held accountable for violating human rights under the Charter because it could not make a decision on its own. Those were some of the arguments put forward. Slowly over time, though, the Court of Justice did try and what's the word I'm looking for? Find some kind of responsibility, but my personal positioning is that the Court of Justice could have done much more for human rights protection when it came to the impact of the austerity measures. And again, if this is something that's interesting for you, I can send you over some information because we don't have too much time to go into all the argumentation. And if you're interested in some of these cases, you can look at leather advertising. You can look at the old case of Pringle. Yeah, so quite interesting stuff. So if someone tells you that the European Union has nothing to do with human rights, they are wrong. Since 2009, the Charter is a fundamental document and has primary status. And don't forget that we also have several directives which are deeply correlated or positively correlated, not deeply, with human rights protection. So we have an array of non-discrimination directives which are all about promoting and protecting the rights of different groups in, for example, the workplace or in accessing vocational training. So we are making a lot of developments when it comes to human rights. Beyond Europe, we have other regional documents such as the American Convention on Human Rights and the African Charter on Human and People's Rights, which are there for the particular regions. Closing the chapter of the different major documents is the question of who is ultimately responsible for upholding human rights. Now, what the Universal Declaration states is that every individual and every organ of society shall strive by teaching and education to promote respect for these rights and freedoms and by progressive measures, national and international, to secure their universal and effective recognition and observance. So the primary role is that of the government to provide us with the framework to enjoy human rights and to protect us from abuse. Because I'll give you an example. X may be a victim of domestic abuse. It is the responsibility of the state to protect that person from that abuse in terms of having helplines, having shelters, having different infrastructure to allow social, psychological, but also financial infrastructure to allow that person to be able to escape that circle of violence. So that's one example of how the state may take measures to protect someone from human rights abuse. There are also other entities, so businesses, and I'll give you the perfect example that we're going to look at on Friday, social networks. These huge networks, I don't know, Facebook, YouTube, Twitter, Instagram, whatever else, they're private companies, but they constitute the major public fora of our new world. So, but they're not bound essentially by international human rights standards. They're bound by I don't know, some corporate social responsibility and some agreements of soft law they've made with institutions such as the European Commission. But essentially, the relationship I have with Facebook is that of contract law. Yeah. Is that really reflective of the reality? Especially because of the stark impact that these companies have. So that's something else we're going to look at on Friday. Civil society, but also individuals. Okay, so there's a variety of actors. The responsibility of the government is to respect human rights, i.e. not come and deprive persons from their rights, to protect them from human rights abuse, i.e. to prevent others from abusing human rights, but also to take positive action to fulfill human rights obligations. Okay, and here I've put you a link for a short, very nice short video on the history of human rights. You can watch it in your own time, so we don't waste any of our group time. And just to wrap up, what I wanted you to keep from today were the basic characteristic of human rights: universality, the fact that they're interrelated, interdependent, the fact that it's very important to keep reminding ourselves of those characteristics, the different major institutions for human rights protection, so the UN and the Council of Europe, and the fact that human rights are part of the functioning of the EU, particularly post-2009. The fact that after the Second World War, this idea of an international community for the protection of human rights was born. So it's not just a matter of a member state. If my country is violating my rights, I can go elsewhere. I can go out of here to ask for help and get help. And the impact of major events, particularly 9/11, in the enjoyment of human rights, particularly by ethnic and religious minorities. Yeah, and just to give you an idea of how the ECHR functions, why do I focus on the ECHR? Because it's the regional court of our area. So UK colleagues, as you know, your departure from the European Union has nothing to do with your belonging and your ability to go to the European Court of Human Rights, because the European Court of Human Rights is an institution of the Council of Europe, and your national legislation, particularly the Human Rights Act of 1998, is the document which has incorporated the European Convention on Human Rights International Law. So the fact that you're leaving the EU has nothing to do with the fact that you can enjoy your rights within a Council of Europe framework. It's only if you leave the Council of Europe. I heard some gossip about that too, but I doubt that. That would affect your access to the ECHR. So that's essentially what I wanted to do today: bring in some legislation, some major historical events, and some basic characteristics to pave the way for looking at the other two themes. So thank you very much. I'm going to stop now. What I suggest is that if you have any questions or comments, could you send them in the text box? Or maybe if you want to speak, that's also fine. I will mute myself now and see if anyone has anything to say or type.